we've done that for a few minutes, then we're going to take questions from you and allow you to ask whatever you want for the remainder of the session.
Great, thanks. So I think what I'd like to do is talk about what I see as the three most important religious liberty lawsuits that are ongoing right now in a particular area or aspect of religious liberty, which has to do with life issues, abortion, contraception, which has really become sort of the front line for religious liberty right now, one of the front lines. So the first case many of you may have heard of is called Little Sisters v. Burwell. And to back up and give a little bit of context as to where this case came from, when President Obama and Democrats rammed Obamacare through Congress, President Obama gave what was sort of the read my lips moment in the religious liberty world, which he said, one thing I promise you, he said this in several different ways, but he assured the American people, and particularly Catholic and religious leaders, that conscience rights would be protected, that in no way would this law violate people's religious beliefs. Well, what he did then, just about as soon as the bill became law, was use a regulatory power through the Department of Health and Human Services to pass a regulation that would require every single employer in America to pay for and provide every type of contraception, including those that are life-ending, so abortifacient, in their health care plans. That totally shocked everybody, and there was sort of an interim period where there was a lot of back and forth that went on. But what ended up resulting was the biggest religious liberty lawsuit in American history. There was scores upon scores of plaintiffs, people who sued, everything from orders of nuns and priests to soup kitchens to businesses who said, we can't abide by this law. To summarize, the lawsuit broke off into two tracks, the for-profit track and the non-for-profit track. And many of you probably heard that last year, the for-profit track was settled with the case of Hobby Lobby. It was a very close call. It was a 5-4 decision at the Supreme Court. And the government's position in this case was that if you are a private employer, and in the case of Hobby Lobby, they had started a business out of their garage. If you're a private employer, you essentially have no religious rights. You have to abide by this law. Thankfully, we narrowly won that case, but the non-for-profit cases are still pending. And on March 23rd, the Supreme Court will hear oral arguments on the case of the Little Sisters. Now, the Little Sisters are a group of nuns who they exist to take care of poor, dying elderly people who would otherwise die in destitute poverty alone. So this is what they exist for, and they're being told by the government that they have to provide in their health care plans things like abortifacient drugs. So that is the first case, and that's an important case to watch. If it's okay, I think we'll do questions in a little bit. The second case is a case called Stormins v. Wiseman. This is a case that has wound its way all the way up to the Supreme Court and has asked the Supreme Court to hear their case. This is a case of two women who are pharmacists in the state of Washington. They are religious women who, because of their religious beliefs, cannot in good conscience fill a prescription for Plan B, whose own FDA label says can destroy an embryo, can cause an abortion. So for folks who believe that life begins at conception, this is a drug that these pharmacists cannot fill. So they have, about 10 years ago, the state of Washington worked with Planned Parenthood to write a law that would require every single pharmacist, regardless of their religious beliefs, to fill this prescription. And believe it or not, it went all the way to the Ninth Circuit, and the Ninth Circuit ruled against these pharmacists. And just a couple of facts about this case which show sort of how ideological the push is behind this lawsuit. There has never been a single woman who's been denied access to Plan B. And these two women and this pharmacy are willing to refer women who are seeking Plan B to one of 30 pharmacies in a 5-mile radius. But this is not enough for the Ninth Circuit, so these two women have now asked the Supreme Court to hear their case. And if they are denied, the Ninth Circuit's decision stands, which would essentially mean that any pharmacist under the jurisdiction of the Ninth Circuit would have to facilitate what in their mind is an abortion. And so if that sounds extreme, the third case is ACLU v. Trinity Healthcare System. Trinity Healthcare System is a Catholic hospital system in the state of Michigan. It is the largest hospital system, and they are being sued by the ACLU because their doctors will not perform surgical abortions. So this is where things are going, and it should frighten you. And I think that Travis is going to talk about another aspect of religious liberty law, and then we'll talk a little bit about what you can do about where this is all going.
Thanks, Ashley. So what I'm going to do is kind of step back a little bit and answer the question, kind of overview, how did we get here? So she's outlining some very alarming cases which we're aware of and are very problematic. There are a number of other problematic cases that have wound their way through the courts. How did we get here? Why are we at this point now in which religious liberty is an issue? Why is it a hot button issue, right? So most of us, I think, going back a few years, perhaps decades, for some others, we think of religious liberty as particularly not very controversial domestically. When we heard of the term, we thought of Iran, North Korea, places overseas where there was persecution of Christians and others. Only recently domestically has the term become more widespread. Has it become a hot button issue? Why is that? I think there are underlying cultural movements and shifts, particularly the advance of sexual rights and demands coming out of the sexual revolution, winding their way into an agenda which is putting itself on a crash course with a lot of mainstream religious claims today, not just Christianity. Religious claims dealing with sexuality, among them contraception and abortion, but also gay rights and other forms of sexuality as people demand rights enshrined into law and accepted culturally in those areas. We're going to see conflicts in the area of religious liberty. Where are we at right now? Well, as you know, the Supreme Court last June demanded or legalized basically same-sex marriage, saying that states under the 14th Amendment must recognize same-sex marriages and from their own states, issue licenses, and recognize those from other states. That's all the decision said. It didn't say anything else, but the decision is a milestone in the cultural battles underlying religious liberty. And no doubt it will be cited and has been already looked to as a way of supporting this idea that culture and law must accept new rights enshrined in law on these issues, these agendas of sexuality, which will cause problems for religious liberty. So where are the problems right now? I think the problems broadly are for anyone who has a nexus or interaction with the government. That's where the pressure point is right now, right? So who is this? People receiving a license from the government, being granted tax-exempt status from the government, being accredited by some agency recognized by the government, contracting with the government, really interacting with the government in any way, receiving federal money, for example, where the government can say, we're going to hold this over your head. You must not discriminate on the grounds of sexual orientation, which really means you must recognize same-sex marriage, according to their interpretation of the matter. This obviously is a religious liberty problem, right? So these are all the places that we're seeing the pressure point right now, politically and culturally, and if you follow the media battles, the media stories at all. So what can we do about this? Really, where are we at? Well, as Ashley outlined, there are court cases involving religious liberty, but religious liberty, it pervades our culture, politics, the cultural acceptability, the norms, mindset, all sorts of areas outside the courts. And this manifests itself politically in some ways. Some of these cases will have to be resolved by court, saying there's a constitutional right or a statutory right to religious freedom that one party has, right? There are laws on the books, the Religious Freedom Restoration Act federally and various state efforts to pass these, and the First Amendment, obviously a long, strong body of law for religious freedom. But the courts won't resolve everything, and certain matters must be resolved statutorily, hence the need for legislative action to pass protections for religious liberty, and thus the protections, in my view, should be focusing on the people currently under threat, those with a nexus with the government, not people currently protected in a stronger manner, such as pastors, churches, the typical bulwarks, the religious institutions we think of as purely religious, churches, pastors, clergy, etc. Those folks are currently protected pretty strongly under the First Amendment right now. They don't need legislative protections, and when states pass protections for them, what they're doing is bowing out of the tougher and more needed fight of passing protections for the people who actually need it. So the term Pastor Protection Act or legislative protections for pastors, I would say, are not needed right now, and they distract from the more needed efforts focusing all those folks with a nexus with the government who have beliefs about marriage or sexuality and contraception, abortion, and I'll say more broadly religious liberty beliefs. The Religious Freedom Restoration Act protects against all sorts of religious claims. It's just these issues are the hot button issues right now, and protections are needed for them, but protections for religious liberty are needed more broadly. So I hope this is helpful for you all to think through the issue in terms of what can we do, what's needed legislatively. At the federal level, the First Amendment Defense Act would protect these people I talked about having a nexus with the government. At the state level, a version of this act, the Government Non-Discrimination Act is sometimes referred to, basically a law which protects all these entities which will come under government pressure for their beliefs on marriage and sexuality. Well, I can get into more of this if you want as we take questions, but these are some of the real hot button issues that I think we're going to be facing going forward. So at this point, what Ashley and I will do is I think we'll both just stand here at the podium and fire away with your questions, and one or both of us will handle them as we see fit.
You mentioned government nexus, but many of these cases have nothing to do with government. Photography, the Elane Photography case, which the Supreme Court, as I recall, refused to hear. So I'm not sure what protections there are going to be, even with state legislation, if the Supreme Court's not going to hear those cases.
Yeah, so the Elane Photography case involved a small business in New Mexico that was sued because they did not want to photograph a same-sex wedding. They were sued under non-discrimination laws. It wound its way to the New Mexico Supreme Court. They actually brought a claim under the state's Religious Freedom Restoration Act, and the New Mexico Supreme Court said, we actually can't decide this because our state Religious Freedom Restoration Act will not permit us to intervene and bring a claim and decide the claim under that law because there's no government actor to the case. The government actor, the state agency that initially received the claim and prosecuted it, had dropped off the case. So through a procedural mechanism, the court said, hey, our hands are washed of this, we don't have to decide it. Really, it was a cop-out because there was government action that brought the claim and enforced it. Whenever there's a non-discrimination law, somebody has to bring that, but then at a minimum, a court, often a government agency, an executive, unaccountable executive agency set up, such as the one that prosecuted the Kleins in Oregon and Washington State, the case involving Barronville Stutzman. These involved executive branch agencies, often unaccountable, a lot of proceedings, nobody even knows how they conduct themselves, and there are all sorts of procedural problems with them, but nevertheless, this is a clear government actor forcing this on the small business. In the Kleins case, finding them $135,000 and emptying their bank account. So, that's the government action in the cases, and it certainly varies, as you point out. It's not the same when the government says we're going to revoke tax exempt status. That's different from a private person bringing a claim, but there's also often some mechanism of government involved in the case.
What about civil litigation?
Well, that isn't.
Because that's two private actors.
It is, and that's an example of civil litigation, but the government entity was involved in it. So if it's purely civil in terms of someone bringing a claim and it comes before a judge, it probably wouldn't fall under the framework that I'm describing as much. And these are issues going to have to be sorted out in other ways. I'm mainly focusing on the government actors, whether direct action, I'm revoking your tax exempt status, or I'm setting up an agency that's going to prosecute my view of sexuality. Yeah.
One thing, speaking to that point, is you can define, in fact, in several of the federal courts, they define a RFRA to apply to private actors if the situation that they're relying on some sort of state law. So in New Mexico, what they were relying on was their non-discrimination statute that dealt with that. And so New Mexico didn't interpret it as if it applied directly to them because of that law. But what New Mexico tried to do, and it blew up and it never happened, was try to redefine, make sure it applied to private situations. But that's what I would, you ought to look and see how your RFRA is interpreted. But if you want to protect the banker, photographer, all those people, then that's what you do, is you make sure that your RFRA actually applies to private actors when they're relying on some sort of state code or municipal code or whatever.
I would tend to concur with that. Yeah. Anything else?
You were talking about the Little Sisters case, which I find really interesting. But one of the things that when I was reading through SCOTUS law, just to get a sense of the case, they actually, HHS provides an exemption, correct? So Little Sisters don't have to provide contraception if they don't want to. All they have to do is tell the HHS or their insurer, correct? So what they're fighting against is they don't even want to provide that notice. Isn't that correct?
Right, so the government has used all sorts of tricky language to make it sound like they're being so accommodating. And there's been numerous back and forths about all different sorts of exemptions. With the Little Sisters, what they have to do, they don't have to pay for the drugs. The government has said, we'll pay for the drugs. You just have to provide them in your health care plan and sign this form saying we're paying for them. So let me think of let's say you're a school and you have a healthy eating program, and you want to ban junk food. And so you want to ban vending machines that sell junk food. This would be like the equivalent of the government coming in and saying, sorry, you still have to have the vending machine on your premises that sells kids junk food, but we're going to pay for the vending machine, and actually we'll even make it free. You just have to let us set this up here. And actually, in the Little Sisters case, you have to sign a form. Maybe in this situation, it'd be like you have to put up a banner alerting people that actually we're a green school and we don't have junk food, but if you want junk food, it's down the hallway. So at the end of the day, the Little Sisters are still implicated. They still have to sign a form saying to their employees that we will provide you these drugs. It's just that we're not paying for them, the government is. And they're saying we can't in good conscience do this. We're still facilitating abortions. Our employees, by the very nature of working for us and being on our health care plans, will have access to life-ending drugs. That's their case.
Other questions?
I just wanted to give sort of 3 concrete action items that I think people who care about this issue can do, because it's, I think, very overwhelming to hear about these cases and feel sort of helpless when you know so much of it is happening at these high court levels, or, as Travis said, with these sort of administrative agencies that hold these kangaroo courts where they, in the case of Colorado, I think they were told they had to be educated, re-educated on their cultural beliefs about religion and how it applied to homosexuality. So I think one thing that's so important for people who care about this issue to do is to use social media. And I think our side is getting a lot better at using social media to get the truth out there, and we're getting a lot better at telling stories. And, as you've heard, our cases are built of these incredibly compelling stories of everyday Americans who, sort of pursued their American dream, whether it was starting a craft shop out of their garage or starting a bakery in Colorado. And so I think if you could challenge yourself to, even just once a week, share on your Facebook page or put out a tweet about one of these stories so that we can continue to just get those stories out there, because we're sort of working against a media that does not want to tell those stories or is deceptive in the way that they report about the stories. I think a second thing is to lobby your representative. I can't tell you how many times I hear from people who work on the Hill that they don't get any phone calls about this issue. And those phone calls matter. When phone lines are melting down, the message goes straight to the top. And I think because of the fact that so much of our power has been taken out of our hands by the courts on this issue, by these administrative agencies, the sort of congressional legislative side of things is probably one of the most powerful ways we can fight back. And after Hobby Lobby, there was a push in Congress to pass a bill that would have overruled the Hobby Lobby decision, that would have, the bill was written in such a way that was actually more extreme than the way HHS wrote the first version of the regulation when it came out. It failed, but a lot of the men and women in Congress who either signed their names to that bill or voted for it were held accountable, and they were tossed out. And I think that's a powerful tool. And the third would be to vote in this election. I want to read a quote from Hillary Clinton when she was asked about whether or not religious employers should be granted exceptions when it comes to whether it's a religious worker in the healthcare industry or an employer when it comes to some of these issues. And her response was, too many women are denied critical access to reproductive health care. And this is the scary part. She said the deep-seated cultural codes, religious beliefs, and structural biases have to be changed. So just keep in mind that she is the Democratic frontrunner right now, and if she is elected, she will be able to fill an essential vacancy on the Supreme Court. And so if you care about religious liberty, this is probably the most important election that you could ever vote in.
I would definitely agree. And let me just add a couple things. You might be sitting here asking, this doesn't affect me. Why should I really care about these issues? I understand they're going on, but how am I personally affected? I want to give you 2 reasons. One, a religious reason. For those of you who go to church, involved in a religious institution, you may not personally feel the threat at this point. The government's not at your doorstep. But the government will eventually be at your doorstep if these trends that I'm talking about, that I mentioned already with those involving a government nexus, the schools, charities, those in getting licensed from the government, if their claims are eventually dismissed, overruled in law, whether legislatively or by courts, those pushing an agenda which has overruled their claims will eventually arrive at the steps of the church. And just because churches receive tax-exempt status now, there's nothing saying this is the way it's always going to be forever in our country. So if we want this to remain as it is, not just churches, but all sorts of other private actors which keep a large, intrusive government at bay, we need to care about fighting the battle where it is now. We'll keep the pressure and the threat away from churches. The second reason is just a constitutional rights reason. What's driving the cultural pressure and manifested in law right now is a mindset, a philosophy. You see it on campuses probably most visibly, that individual constitutional rights, pluralism, differences are not really necessary or useful. Everyone shall conform to the proper moral view that the government or authority, educational authority or government has promulgated for what's best for society. So we're going to make you do this because this is good, we think it's good, and you shall believe and act this way. This is manifested perhaps most strongly in a very aggressive application of non-discrimination laws and government pressure on people to conform their moral views. And this affects the First Amendment, obviously, because this view would say we're going to trump the religious rights in the First Amendment, but not just the First Amendment, every of the Bill of Rights, every constitutional individual right or civil right, statutory right, which says individuals can have their beliefs and be protected and manifest those beliefs and not be under threat from the government. That is premised on a philosophy that individual expression is good, even when it's different, right? So this mindset, which is percolating up through campuses, being manifested in culture, which you see being pushed by Hollywood, the media, big business a lot of the time, this mindset will drive not just the threats to religious liberty, but threats to every other individual constitutional right. And even if you're not a religious person, this is why you should care about the issue. So most I would say immediately, as I mentioned, the need for legislative protections for all these people who are involved in some interaction with the government to be able to live out their beliefs as they wish. Obviously, the court cases are important, and they will determine a lot. But this is the area, as Ashley mentioned, with lobbying members of Congress and our state legislators, that we can have the most immediate impact is by demanding they protect these people who really need it most immediately. So I know we've just kind of ate up some time there, but I think we'll take any other questions before we finish, and then I think I'll be around at least. We'll be around for a few minutes to talk to you afterwards if anyone doesn't have any questions now. Yep.
Are you familiar with the compelling government interest doctrine?
I am, yep.
Are you familiar with the Parental Rights Amendment?
The Parental Rights Amendment?
The proposed Parental Rights Amendment?
No, I'm not familiar with that.
It would essentially render unto Caesar that which is God's, which is the parent's right to make decisions for his children.
Yeah, we can talk after. This is an example of an area, right, that's not specifically, right, a religious liberty issue. There's some overlap. Again, individual rights in the face of a government forcing conformity. Yep.
I'm Bob Allen, legislator from Arkansas, and I actually carried a RFRA legislation last year, which of course blew up and got real excited and all that. But we did get it passed into law, so if anybody has any questions,
Yeah.
anything I can help with, if you got contact with the legislator, you are a legislator, and interested to do it, I can kind of give you some insight.
Curious though about state reference or compared when looking at in relation to the grounding of Burwell and then a lot of these, go back to Romer with the animus, the animus grounding supposedly these of some of this legislation. The state reference have a chance when they come up against the animus.
Well, a RFRA is a framework that allows a claim to be processed by courts in a certain way. It sets a standard, and a lot is yet to be determined, which kind of defeats the point that these are somehow the end of the world and a horrible thing for society. And I'll just give some credit to Arkansas. You guys passed a good RFRA modeling the federal RFRA in the face of cries in the media that this was going to be in the world in Arkansas. It was horrible. Where are these people now who are crying, as if this was the end of the world? Arkansas is proof that this can be done. It's a good thing, and people are going to be protected now because they're law. So I think we need to finish up here. But I'm happy to talk to anyone who wants to talk about these issues, even if we have to exit the room. I'll just let Ashley have a concluding word if you want to
I
say
think
something.
I'm good.
Okay. Well, thanks for joining us today. These are important issues. I work at the Family Research Council. You can go to our website, frc.org, and find information. Contact me at tsw@frc.org. If you want to know anything more, and I'm happy to talk to you all afterwards, too. Thanks for being here.
Thank you.
Definitely want.
Okay. All right, thanks. I'll take a look at this.
Okay.
At the very bottom.